Hello, everyone. I'm Masha Antokolskaia, and I'm very glad to speak today to you. I am Professor of Family and Private Law at the Vrije Universiteit Amsterdam and Chair of the Family in Law Academic Network, FLEUR. And I'm going to present you the first results that have been achieved by FLEUR so far. But first of all, I will tell a few words what FLEUR actually is. Well, FLEUR has been established in Amsterdam in 2019. You can look at the website for more details. And this is a private academic initiative. That is to say, it's not established by government, and all the members are on their own academic title. So they are not appointed by their respective governments. At this moment, we have 30 experts from 28 European jurisdictions. This is FLEUR, and this is a little flower that has been made by a woman who was paralyzed up to her neck and still learned how to draw with having a pencil in her mouth. So we thought might be appropriate. And what is actually the aim of the FLEUR? It's close academic cooperation in the field of family law aimed at accumulation and dissemination knowledge, both family law in books and family law in action, a promotion of comparative and multidisciplinary research and education, learning from one another experience, providing up-to-date comparative data for European, supranational, national bodies, but it's not aimed at harmonization. So, as you saw, there are various working fields that could be possibly chosen, and the members of the FLEUR are not experts in a particular field of family law, but more in family law and private law in the broad sense of it. So one of the fields has had to be chosen as the first field. So these are the number of fields that could be chosen, and we really considered three very different fields in the first meeting, like high conflict divorce and new aspects of parentage, and also empowerment and protection of vulnerable adults. And finally, the members of the FLEUR have chosen empowerment and protection of vulnerable adults as the first field, because we were all very much convinced that this is extremely important subject. As you see, we use the word vulnerable, which in the current context, not always very well politically correct, but we come, we share the conviction that actually we are all vulnerable, some more, some less. So there would be no negative connotation of this word. And these are people which a bit more vulnerabilities than the rest, nothing else. So what is the working method? We've already made quick scans of 28 jurisdictions, and they are on the FLEUR website. And after that, a questionnaire is being drafted. It's finalized now and sent to the members. This is a very difficult process because we have chosen two attitudes. First of all, it's really a comparative work. So on the basis of the quick scans, with a smaller group consisting of 8 persons representing different jurisdictions, it's very important to look at all possible differences in the jurisdictions covered, so nothing is missed and everyone could really fill in this questionnaire and answer to all the questions that are related to the jurisdictions. Some have institutions that others don't. Some jurisdictions have been quite far with reforming their family law, others are still starting. So it's very important that this questionnaire would be all embracing, that everyone could describe their own law using it. This is first one, and then there are several drafting methods. And one is that you pose quite general questions and leave a lot of room for the reporters to answer them. We have chosen for quite detailed questionnaire, which really takes the reporters by the hand and guides them through the questionnaire. And this way we could quite surely know that they wouldn't go astray, wouldn't just not know what is exactly meant. Well, the other side of this is, of course, that when you ask questions quite specifically, some could just feel that it doesn't apply to their jurisdictions. So this is also quite difficult to use this technique. Therefore, it took quite some time to make it. The next step that we expect to be completed at the 1st of September 2022 is that the country reporters, the members of the FLEUR, would make their reports. That would be quite a lengthy pieces. We hope that there will be detailed reports and they will cover a lot of stuff. I will come in a few minutes to more details considering their jurisdictions. As I said, that our members are not necessarily experts in this particular field. They were free to involve co-reporters, the real experts in this particular field. And so the several has done it. So we will be actually with more than 30 persons drafting these reports. After the reports would be made, then we would try to uncover what is common, what is different, what are the best practices, and what are the pitfalls. And here we have quite a clear guidance because we have CRPD and we actually know where everyone wants to end up with, well, some little uncertainties on that point, how strict, how far. And so it's very easy to say this is a common goal to implement CRPD requirements as well as possible, but then everyone has different techniques, different starting points, different environment in their jurisdictions. And after that would be done, we would not make any draft principles or things like that, but just put together a range of possible solutions that could be then voluntarily used by governments, European and international organizations, and professional and other organizations. This is the kind of time pass. We see that the quick scans are already made, and then because of the COVID, we had quite a delay in drafting the questionnaire, also because it was very demanding, and we were thinking that this turbulent year and a half would not be really a very suitable period to ask the reporters to make their reports. So finally the questionnaire was sent in May 2021, actually in June even. And now is the first conference which is initiated by the FLEUR and organized together with Swiss Institute of Comparative Law and the Faculty Law of University of Geneva, who then really put even more efforts in the organization than FLEUR did. So it's absolutely equal participation in this. And this is the moment that we will present the very first results, mainly the starting points of the questionnaire, but also one of the purposes from the FLEUR perspective is that the members who are now starting to draft their reports would get a theoretical feedback from the leading experts in the field from all over Europe. So it's extremely important that these recorded presentations and also the conference itself would be followed, because there they will get really the insight into the starting points, dilemmas, discussions, difficulties, theoretical difficulties in this field of protection of vulnerable adults. Then we expect that the reports would come in September 2022. They will be initially analyzed. That will also take some time. And then the second conference would come, and at that conference, we could already in 2023, we could be able to compare, to see, to map, to uncover what really is in various jurisdictions. That could, of course, provide a lot of information for everything, for instance, also for application of 2000 Hague Convention, because you need to know in details what is the content of applicable law, but also for many other things. After that, we will start in deep analysis of the national reports. We would look at common core, best practices, pitfalls. And after that, the second conference would really, I hope in 2025, it will really take time. We will be able to present actually what can we learn from one another. That is the most important, and put a range of possible solutions. So saying that you can do this, you can do that, and it depends on the content of context of your system and many other factors. But now the questionnaire. Well, questionnaire has 7 parts and starts also with the part where we try to explain terminology. Terminology is extremely difficult because countries, of course, have their own terms in their native languages. After that, they have, as the questionnaires would be, the reports in the questionnaire are in English, they will translate these terms into English. And we saw already in their quick scans that they would use all kinds of terms. In Adrian Ward presentation, you also see the numerous possible translations of the titles of the measures into English. Sometimes these translations have been already official translations, English translation used in their jurisdiction. Sometimes they have to invent something. But here we have what is in comparative law is called, you know, there is a functional equivalence when we call things with the same name, but they are very different. But in this case, it's a kind of functional disequivalence. The things could be called guardianship or curatorship and mean completely different things. So to deal with that, we actually try to, as far as possible, to lean to existing terminology and definitions. First of all, provided by the CRPD, by the committee, by the general comments, and also by the Council of Europe recommendation. We deliberately did not use a term guardian, because this term, it's like irretrievable breakdown in the law, in divorce. Everyone uses it, but it means it could mean something completely different from jurisdiction to jurisdiction. So we said, if you use it, just explain what do you mean by that, if it's official translation in your jurisdiction, because some put new wine in this old wine skin, and it is completely reformed measure, but it's still called guardianship. Some didn't, so it would be this classical old-fashioned concept of guardianship with substitute decision making, and it will also be called guardianship. So we really wanted attention to use of this term. We asked also to all reporters to start with this short list of terms and definitions. So if you use a word guardianship, just define what do you mean in your jurisdiction by that. And then another thing, we ask to provide also the titles in the own language of the jurisdictions. And in the jurisdictions that use other alphabet than Latin, to do it also in their own alphabet and then in Latin, so that we could retrieve and go back to the differences that could be hidden behind the use of the same terms. Well, then the questionnaire starts with a general part, and we all would very much like to have not only the black letter law reports, but also an overview of historical and policy background. How did this come to existence? To have some embedment in this system as a whole. How does it operate? Where does it belong to? In which part of the system? A brief description of the current legal framework. And also, if there is any empirical information, any statistical data or kind of things like that, we would also like very much to have it. We also ask to pay attention to any discussions that are going on at that moment, controversies, pending reforms, and things alike, bills of law that have recently been rejected. And also we ask for evaluation. This evaluation could be also done by the reporter themselves, but also the evaluation that exists, and also counter reports to CRPD or any other evaluations by the government, by independent organizations, or any other things. Why do we ask the reporters themselves to give a brief explanation and brief description of their system? Because then after that we have this detailed questionnaire, and one can say, you can do that. You can just, deduce from the answers, the description. We are very much afraid, and this is also experience from comparative work, that we would still misunderstand something. It's extremely important that the native to the jurisdiction reporter, his or herself describes how the system operates, because that is a very important kind of checkpoint for us, whether we really understand how the system functions and operates. Then limitation of legal capacity. In the beginning of this section, we explicitly ask, does your system still allow for that? Because some systems would not. They went quite far in line of the requirements of CRPD, and they do not have the notion of limitation of legal capacity. If this is possible, then this it's of course a very short abridgment of lengthy part. So don't think that this is the question. It's, in my own words, a very short abridgment of what is there. So what are the grounds? What are the scope? And is it tailor-made? Does it automatically take effect if some measures are applied, or if there is the possibility for tailor-made limitation? And then restoration, who can ask for it? What are the grounds? And then very important thing, whether the application of a measure automatically results in limitation or deprivation, or this is a separate decision, tailor-made decision. There are also some differences between the systems, of course, because some systems has a notion and distinction between a passive and active legal capacity. Others don't. And passive legal capacity basically cannot be limited to restriction, and active, well. And then there are also some other things which is which are important to bear in mind when considering this, is actually how does it work if a country formally have denounced the possibility of limitation of legal capacity. How do they deal with cases when a person is, for instance, in coma, which is called hard cases? So the question, to put it plainly, is it not that limitation of legal capacity has been kicked publicly out of the front door and then led to get into back through the back door? So do you use other instruments or other tools that could lead to the same effect, whether you don't call it depriving legal capacity, like, for instance, the requirements of general contract law, family law? Because if you say that only persons who are completely compos mentis could, for instance, be a guardian of a minor, then we already see that you don't need a concept of limitation of legal capacity in your law to limit it in some way. And reflection and evaluation and the problems that in the jurisdiction have been found. Then state audit measures. Well, all systems have state audit measures. This is also, all systems are in transition. They tried to revise those measures in line with CRPD. Some did it prior to the ratification of the convention. Others are inspired by the convention, and others are still considering their changes. So we see that we ask for to describe the system. We ask for each measure to describe the legal grounds, the legal sources, the procedure of application, the appointment of representative or support persons, and also to specify whether they are representative or support persons, to reflect on the legal effects of the measure, also as to the legal capacity of the adults, and power and duties of representative support persons, safeguards and supervision, and how the measure ends, and reflection and evaluation. So this is quite easy, more or less. And now, voluntary measures. Well, these measures would probably in the future have more and more priority. Most systems already have them, some not, and they are in the process of also including them, developing them, and they could profit, of course, from the experience of the others. So voluntary measure is actually something that the adult could make for him or herself in the period of the pending future period of well, incapacity. You can appoint a representative or a support person, but you can also, without appointment, give an advance directive, only specifying what your wishes are. And then we ask for system and definition of the measures. We ask for the legal source and the nature, because the different countries use very different legal tools. Also, the question, who has the capacity to grant this measure, the formalities, the registration, the publicity given to this measure, the other surrounding legal requirements. When the measure enters into force is also an interesting question, because when you make it, you should be compos mentis still, and then you can specify that it would immediately enter into force or at a certain moment in the future, and that moment has to be specified and has to be determined, and at that moment very important transition would happen. Then appointment of representative support person, who can be appointed, who can several persons be appointed at the same time, and how then their powers would be divided. And then also what effect would it have on legal capacity of adults? Can this representative act in place of the adult, or can it act together or provide assistance in which matters could be covered, and also criteria for decision making. This is also important, of course, for the state audit measures. This is best interests of adults or will of preferences, the old principle or the new principle that is laid down in CRPD. So we try to capture the transitions that countries are made on every aspect. And also just one word about the terminology. We use the terminology voluntary measure because that's quite clear. The adult takes initiative and it's his own volition to or her to make this measure. But in regard of the state audit measures, we don't say involuntary because the adult himself or herself could also initiate application of the measure. Then guarantees and supervision, which is extremely important, and there is a great variety. In some countries, there is no mandatory supervision, like in the Netherlands. In other countries, there is experience in various types of guarantees and supervision, and it's very important to have them very clearly described so that countries and jurisdictions could learn from one another. End of the measure and reflection and evaluation as everywhere. Then the actually last set of measures is ex lege representation. That we see that some systems do have it, others not. And then it's very also important to see how does this system operates. First, what are these measures and how they take effect? When, for instance, you say that close family member of partner could, by operation of law, represent in some situations, when this power starts, do you need a medical statement in regard of the person who needs this representation? How the third parties would know? Is there registration, publicity, notification, or other things? And then you, also very important is the autonomy of the adult. If you have this system, can the adult opt out when he or she is still mentally capable by, for instance, saying, I don't want this to be applied to me at all. In any case, I don't want it in regard of certain acts, or I don't want this particular person who is most, for instance, is one of my children, who would be to act as my representative. And powers and duties in which fields, in which, to what extent, and also how would you then act instead, or would you act along with the adult? Would you use best interest principle or principle of the own will and preferences? Guarantees and supervisions, and of the measure, reflection and evaluation as always. Then there are some specific cases in some countries like family, matrimonial property and marital law, who give some power, then some general institutes of private law, and then we're just asked to specify if there is anything else, and also whether third parties could make provisions, like, for instance, parents who care for an adult child with disabilities, or other third persons who can then transfer or make arrangements for the person with disability, mainly they do care for many years. Well, and the very last part is the general assessment. So we ask the reporters to assess the system themselves, using, of course, their own abilities, but also all reports that they are academic literature, political discussion, to assess their own system, whether it has made the transition from substitute to supported decision making, whether the subsidiarity to autonomous decision making has been taking place, where the substitute decision making, if it's still possible in this system, is it really a last resort measure, and how does this ensure it? Proportionality, so where to see where the also substitute decision making and representation is last resort, and the less infringing measure has priority upon the more infringing measure, and the voluntary measures have priority against the state audit measures, so that really the tailor-made proportional approach is ensured. And then what kind of effect the measures have on legal capacity, how far it restricts it, and if the whether the tailor-made solutions are possible, both in restriction and limitation of legal capacity, if it's possible under this system, and in application of the measures. And also whether the transition from the best interest principle to the principle of own will and preferences has been taking place, and how deep is this transition. This is in the way when it comes to the decision-making process. What criteria does the representative support person uses in the situation when the adult can no longer express, for instance, will and preferences, whether you will look then to what this adult would have done or decided if she or he would still be capable, or you just go back to the principle that has been used before and that's still used for the minors, the best interest principle, which is actually disadvised to use in regard of the adults. And if this principle is still used, is it really used in last resort when the adult cannot express his own will and preferences, and there is no way of uncovering what own will of preference would have been in this situation, if the adult would still be able to he or herself decide. Then another set of questions is posed, actually, because the CRPD and the whole project that the FLEUR has, and also the title of this conference, is balancing autonomy and protection, balancing empowerment and protection. So we should not just look at the empowerment and autonomy, because if you strengthen empowerment, it's like a communicating vessels. It goes at expense most times of the protection. Protection means more paternalism, empowerment means more autonomy, and we need to balance it, because also the convention requires that this would not really imperil the level of protection. So you need to, first of all, to see whether protection is set in place in all the procedures that regard the prevention, limitation, or restoration of legal capacity. When the measures are applied, whether the adult is duly protected, for instance, in the Netherlands, when the a measure is attributed, the adult is not legally represented. And the Netherlands is the country where legal representation in most civil cases is mandatory, but not in this. And I recently talked to some judges and they say, well, that's no problem because the special judge has wide discretional power, is trained and really wants the best for the adult. But if we look at the quality of arms at this most crucial moment that you in Holland, the application of measure automatically affects your legal capacity, you are left alone. You don't have your own legal representative. So this is a case that you need to describe whether the protection, due protection, is in place in these procedures, but also during the operation of the measure. Could the measure sufficiently protect the adult against his or her own ill-considered acts? For instance, if we have voluntary measures, most of them do not affect legal capacity. That's very fine. But then if I would, for instance, being in a deep stage of dementia, would watch a TV program and think, well, what a pitiful scenery of stray cats in Greece. I would like to donate all my assets to the charity, and I do. Would I be protected against this act if I transfer the money from my bank account to the charity account, while I'm really not anymore able to duly consider the consequences of my action because I really need this money for my own care? The protection of adults in case of conflict of interest, abuse or neglect by representative supporting persons, the family, the professional representatives, the other persons who can come into the situation. And also when the adults are in institutional residential care. We will have a special presentation by Vilina Todorova during the conference, but also in some countries like Bulgaria or Russia, when an vulnerable adult can no longer live alone and there is no one who can take this person in home to provide also a home and care for this person is placed in institutional care, and this institution is becoming a guardian. And this means, from the point of view of the modern view of adult protection, some absurd situation, because any institution to which an adult could be placed is a just contractual party in civil law that provides care, medical treatment, housing, and other things. And if this person is also a guardian, then it represents also the adult in relationship with itself, because you are a counterpartner in this relationship where you provide care and medical assistance and other things. So in more advanced jurisdictions, it's even strictly forbidden that if an adult is in such an institution, then this institution or any person who is employed by this institution takes the position of a representative supporting person. So this is also something that should be considered at length in the jurisdiction that still have these problems. And also privacy of vulnerable adult, that when it comes to publicity given to measures and limitations of legal capacity. So this is what we ask from the reporters themselves, and we hope that in the end we will have these very detailed reports, that all our reporters will become very knowledgeable if they are not yet in the field, and that they will use the support of the experts, the core reporters. And then we hope that this work, which would be made public without any paywall, all results would be just published, on the FLEUR website and otherwise in open access sources that would really help all of us in Europe and also in other countries to get better understanding of functioning of one another's systems and of, well, the ends of the implementation of CRPD in our jurisdictions. Well, I would like to thank you for the attention, and you can send comments that would be very much appreciated. And I would also like to ask you, well, to be a little bit cautious with distributing this because it's work in progress, and I don't want it to be put just in open internet, but you can feel very free to use it in professional circles. Thank you very much for your attention, and I would be very glad to see all of you during the conference itself.